Hi, in this video, we will learn about the concept of valuation under the IBC, both under CARP as well as under the liquidation process. First things first, under the CARP, there is a mandate of appointing minimum of two valuers by the resolution professional. And these valuers should be registered valuers who should have been registered with the IBBI. And this registration is followed by, or rather before the registration they should have given their examination for registered valuers, and they should have cleared that examination in order to get the registration from the IBBI. And once they are registered as registered valuers, they will be eligible for appointment in the assignments of CARP. So a resolution professional will have to appoint two registered valuers for each class of asset. So there are three classes of assets which we will discuss in the subsequent slides. But for each class of asset, we need to appoint two registered valuers, meaning we will appoint a total of six registered valuers. If it is a registered valuer entity which has the registration for all the three classes, then appointment of that one single entity is sufficient to take care of all the three classes. So therefore, two registered valuer entities, if you appoint, that will be sufficient compliance to ensure that there are two different values ascertained for each class of asset, right? So this is in the liquidation process. Now, when it comes to the this is in the resolution CARP, corporate insolvency resolution process. But when it comes to liquidation, in case of liquidation, the liquidator also will have to appoint two registered valuers, right? Now, the distinction between appointment by the RP and appointment by the liquidator are that in case of RP, the appointment of the valuers is for the purposes of ascertaining liquidation value and the fair value. Whereas in the case of liquidator, the appointment is to determine the realizable value of the assets or business of the corporate debtor. So this is the basic introduction in terms of the registered valuer. Now coming to the valuation date. So if you know about valuation, you would have already known that the most crucial aspect of valuation is the date on which you are valuing a particular asset, which is a valuation date. So valuation as on an X date is something which is going to determine a lot of factors. The market conditions or assumptions, everything boils down to what is the value on a specific date. Now, who is going to freeze this date in a CARP process or a liquidation process, right? So that's something which lawmakers do not want it to be discretionary or in the hands of the liquidator or the RP. So they made a law very clear that in the cases of CARP, the valuation date will be the insolvency commencement date. That is the date on which the corporate insolvency resolution process has commenced. The date on which NCLT admitted this company into CARP will be the date on which the valuation has to be done. So meaning a valuer has to go step back and take all those conditions existing as on the insolvency commencement date in order to come out with his report of valuation. If it is a liquidation process, the valuation should be as on the liquidation commencement date. Then there can be a question, right? That what if RP has already got registered valuers appointed and valuation reports have already in place? In such a case, should the liquidator reappoint valuers, or should the liquidator ask the existing valuers to again work on the valuation as on the liquidation commencement date? Park this question. We'll discuss this in the coming slides. So as I said on the previous slides, we have three classes of assets which are recognized for which we need to do the valuation, which are land and building, plant and machinery, and securities and financial assets. So as you can understand from the names, these three classes of assets, I mean, all the assets of a company should be bracketed under these three classes. And for each class of asset, we will be having two registered values. For land and building, we have two registered values. For plant and machinery, we will have two registered values. And for securities and financial assets, we'll have two registered values. All these registered values will individually provide their valuations under each class of asset. And the average of these two registered values will be something which will be considered as the value of that particular class of asset. Meaning, let's say there are two valuers, valuer 1, valuer 2 in land and building. Valuer 1 has come up with a valuation of 200 rupees. Valuer 2 has come up with a valuation of 150 rupees. So the average, which is 175, will be the value of land and building as a class of that particular corporate debtor. So the average of these estimates is something which is considered as the value, right? So the word again they use is estimate. So the estimates of the liquidation and liquidation value and the fair value is something which registered values appointed under the CARP process will be providing for. And if it is a liquidation process, if they're appointed in the liquidation process, they will be providing the estimated realizable value, right? So we will understand the distinction between these values in the next slide. Yeah. Coming to the fair value and the liquidation value. So as per the IBBI regulations, it mandates the registered valuers to provide for an estimate, right? As I was explaining, estimate of the fair value and the liquidation value, which is computed in accordance with the internationally accepted valuation standards. So we, as in the country, we don't have any recognized valuation standards being adopted. ICAI, of course, has its valuation standards laid down in accordance with the international valuation standards. So wherever there is some ambiguity or question, the valuers will can refer to that. But apart from that, there are IVRS international valuation standards, where IVS international valuation standards where we have definitions for fair value, liquidation value, how to ascertain it, various circumstances like things like premise, how do you determine the premise and how do you do the valuation are clearly laid out in those regulations, and it can be adopted from there. And apart from that, in fact, even the IBBA regulations do define what is a fair value and a liquidation value. And apart from this, the regulations also mandate that the valuer has to physically verify the inventory and the fixed assets. So when it comes to securities and financial assets, other book entries and all you can look from the books, whereas inventory or if it's plant and machinery or fixed assets, you will have to 100% go and visit is something which is mandated, right? And yeah, there is one interesting aspect of this fair value liquidation value is that, let's see, as I said, we appoint two registered values, right? Now, both the values may have a different methodology which they're adopting in order to ascertain the value of the asset. And as an independent professional, we cannot mandate them as RP. I cannot tell them, boss, you only have to use this methodology. We'll have to leave it to their discretion because that is the whole point of appointing a registered valuer. So, basis that discretion, the registered valuers will come up with a value, right? But before they compute their estimates, as RPs, we will have to facilitate a meeting with the committee of creditors. And in such meeting, the registered valuers shall explain the methodology adopted by them. This will be explained to the committee of creditors. And if the committee of creditors come up with some suggestions, the valuers may take that. And if the valuers want to adopt it, they can, or otherwise they need not. But the whole idea is that before they give the estimates of the values, they will come up and explain the methodology which they've adopted in computing the estimates of liquidation and fair value, right? So over here, we usually have to ensure that the valuers do not disclose the numbers to the committee of creditors. They should strictly restrain their discussion only to the limited extent of explaining the methodology, right? Let's now understand what happens in a liquidation process. See, in a liquidation process, typically a valuer may rely on the valuation which is arrived in the CARP. So as I asked you to park a question, right? So let us answer that. In the CARP, the RP had already appointed the valuers and the valuation reports are already out. Now, in the liquidation process, the regulations do allow the liquidator to rely on the valuation report prescribed by the resolution professional. Oh, sorry, the valuation report already submitted to the resolution professional, and that valuation report can be relied, and the liquidator can do to do the sale of assets using the valuations asset arrived at from the valuations done during the CARP process. But if the liquidator is of the opinion that a fresh valuation is essential or is necessary or will be beneficial to the company, or if the liquidator feels that, okay, I mean, or maybe the committee, the stakeholders consultation committee also has an opinion that it's better to have a new valuation done. Of course, ultimately at the discretion of the liquidator can come up with appointing two registered values for each class of assets. The principles of appointment remain the same. And one more thing, what if during the CIRP, the RP could not appoint a valuer for whatever be the reason, or the valuers who have been appointed could not complete their reports? In either of this situation, as a liquidator, you are mandated to ensure that you are getting either fresh appointments done, or the existing values should ensure that they are giving the realizable value instead of fair value and liquidation value. They have to come out and give the realizable value as part of their valuation reports, right? And even as part of this process of liquidation, the liquidator should facilitate a meeting with the stakeholders consultation committee, wherein the valuers will be explaining the reasons, right? Explaining the methodology. So firstly, there will be a meeting where the valuers will be explaining the methodology, and second, wherever there is a deviation in the value of assets by more than 25%, then in the liquidation process, the valuers have to explain to the committee as to why there is a deviation of more than 25% between their values. So this is something which is mandated in the liquidation process. Yeah. And then, of course, after the values are ascertained by both the valuers in the liquidation process or in the corporate insolvency resolution process, the average of these values will be taken in order to ascertain either the fair value liquidation value in CIRP or realizable value in the liquidation process. So the average of the two estimates provided by the registered valuers of each class will be the value of that particular class. So the average is an extremely important thing. Finally, when do we need a third registered valuer to be appointed? This happens only in the CIRP process, and the criteria is the same. The criteria is where there is a variance or a difference, which is termed as a significant difference. So where the values or the estimates of the value of each class ascertained by the registered valuers is significantly different, meaning varying more than 25%. In such a case, in case of CIRP, the resolution professional shall engage a third registered valuer. Whereas in the case of liquidation process, the existing valuers will come and explain the reasons why there is a variation of more than 25%. That's all. But in a CIRP, a corporate insolvency resolution process, if there is a variation of more than 25% between the values ascertained by the two registered values in the same class of assets, then the RP shall mandatorily appoint a third registered valuer, which is mandated under the regulations. And once you appoint a third registered valuer, even then there may be a difference of more than 25% between each of them. In such a case, you have to take the closest estimates. So there are three values, right? So which means you get three values. Between these three values, take two values which have the closest variance. So the closest estimates will be taken, and the average of those two values will be considered as the value of that particular class of asset. So that's how we ascertain there. And in case of liquidation process, as I said, there is no question of appointing a third valuer. These two values will first come forward before the committee, and they'll simply explain the reasons why there is a difference of more than 25%. So that is about appointing a third registered valuer, right? Which is not mandated in liquidation process. But in the corporate insolvency resolution process, there is also another ground where we can appoint a third registered valuers, which is upon proposal from the committee of creditors to appoint a third registered valuer. Let's say the committee of creditors have gone through both the valuation reports, but they're not convinced. They have, even though the reports are similar and the difference is not, difference is kind of negligible, and it's on par with what's expected, but they may still have a opinion that, we may need a third registered valuer who let's see if they can comprehend the same, or if they're coming out with a different methodology. So if basis the committee's proposal, the RP again will be mandated to appoint a third registered valuer. So this is all about the concept of valuation under IBC, particularly in the CIRP and the liquidation process. I hope you have certain learnings in this video. If you have any queries or questions, please drop them in the comments, and please don't forget to subscribe to Virtual Law. Thank you.